She was standing in front of the excavator with her arms spread wide before I'd even nodded at the crew to begin. Stop. Stop right now. You are destroying community property. Her white SUV was still running, door hanging open, 2 HOA board members jogging to catch up behind her. Karen was already photographing the machine, then the operator, then me. No deed in her hands. No permit of her own. Just a phone and complete, unshakable certainty.
I am calling 911.
She said, loud enough for the neighbors already gathering at their driveways.
This man will be removed.
I reached back and touched the folded demolition permit in my pocket. County issued my parcel number printed at the top. On my truck dashboard, visible through the windshield, sat a deed envelope. My name. 11 years. She hadn't asked to see either. I didn't correct her. Not yet. People who are that certain about something they've never verified tend to be the most educational to watch when they finally run out of runway. The cabin had been sitting on my lot for 14 months. 400 square feet of wood frame, an HOA placard bolted to the front door like it meant something. It sat dead center on the parcel I'd owned, since before half of those board members had moved into the neighborhood. My county survey stakes ran clean along the property line. The cabin sat entirely on my side of them, not partly, not ambiguously, entirely. I'd warned them twice, certified mail, signed return receipts, both ignored. That morning I'd arrived at 7 with a 3-man demolition crew and a compact excavator. The permit had come through 3 days prior, tied to my parcel number, county clerk's stamp on the front, everything in order. I hadn't called Karen. I hadn't called the board. I wasn't required to. The crew had been running equipment prep for 15 minutes when the white SUV mounted the curb. Karen walked directly in front of the excavator with both arms out, like a crossing guard. Like she had the authority to stop anything she decided to stop. This was built with community funds, she told the crew chief, who looked at me. It is on community land. You do not have the authority to touch it. She turned to the neighbors. 7 families now still in their morning clothes, coffee cups in hand, watching from the sidewalk. She raised her voice for their benefit. This man is vandalizing a structure that belongs to every family in this neighborhood. What he's doing is criminal destruction of community property. Then she walked to the cabin door and pressed her palm flat against the HOA placard, held it there. This was approved by this board. Her eyes found mine. It was built with community funds. It is on community land. She let the pause land. It is not yours. Then quieter, like she was correcting an honest mistake. I don't know who told you this was your property, but you are wrong. 11 years of property tax receipts. 11 years of my name on a county record that existed long before any HOA vote, any community fund, any placard bolted to any door. I looked at the deed envelope on my dashboard. I kept my mouth shut. The officers arrived in under 10 minutes. Karen was at their window before they'd finished parking. This man is demolishing a community structure without authorization. He needs to be removed immediately. The first officer stepped out and looked over at me. Sir, do you have documentation for this work? I handed him the demolition permit. County issued, valid, my parcel number printed in the header. He read it. His partner cross-referenced the parcel map on the vehicle terminal. About 30 seconds of quiet. Ma'am, the first officer said, turning back to Karen. This permit is valid for this address. It's his land. That is impossible. Her voice went completely flat. This is HOA property. Check our records. We go by county records, ma'am. She looked at the permit in his hand, then at his partner, then at me. I watched something move behind her eyes, not doubt exactly, more like the first crack in the floor of a room she'd always believed was solid. I turned to the crew chief and nodded once. The excavator arm swung into the first wall. The framing buckled with a sound that carried to the end of the block. Karen's voice went up 2 full octaves the instant the wood came apart. She was already on her phone. Board attorney, I assumed, pacing the edge of the lot, pointing at the machine, pointing at me, pointing at the 2 officers who'd stepped back to the sidewalk and were watching the same thing everyone else was watching. I stood 20 feet away with my arms crossed and let it happen. She invoked HOA votes, community investment, board authorizations, architectural committee approvals, founding documents, meeting minutes, every mechanism she'd used for 6 years to make 96 families think twice before painting their front door the wrong shade of beige. Layer after layer of HOA authority, delivered at volume. Not once did she ask to see the deed. Not once did she ask for the parcel number. Not once did she ask the one question that might have told her, 14 months ago, that none of those layers carried a single ounce of legal weight against a county-recorded title. She kept screaming community property at me like the phrase had legal force. She had no idea that the county's records had carried exactly one name on that parcel for 11 straight years. Mine. The cabin was down before 9 o'clock. The neighbors drifted back inside one by one. Karen was still on her phone when I climbed into my truck. I looked at the deed envelope on the dashboard for a moment, then put the truck in reverse. The demolition was the easy part. Before I'd made that call, I had spent 3 weeks building something Karen couldn't knock down with any number of HOA votes or community fund dollars. Not a cabin, a paper trail. And in 6 weeks, I was going to sit 4 feet away from her in a courtroom and watch a judge read it out loud, while Karen stood there and ran completely out of answers. Scene 2. How Karen built a cabin on someone else's land. I bought the corner parcel 11 years ago as part of the same transaction as my house. The main lot, the house itself, and a small adjacent parcel sitting at the end of the block, quiet, flat, a little overgrown when I first got it. I cleared it out, put in a garden for a few summers, used it mostly as a buffer and storage space. Nothing remarkable about it. I paid the property taxes every year without thinking much about it, same as anything else I owned. My name was on the county deed. That was the whole story, as far as I was concerned. Land with a recorded deed, paid up taxes, and a known owner doesn't usually attract trouble. Then, 6 years ago, a woman named Karen ran unopposed for HOA president. The previous president had stepped down with the quiet exhaustion of a man who'd spent 2 terms trying to explain basic procedure to someone who'd decided procedure was only useful when it served her purposes. Karen ran without a competing candidate, because by that point most of the neighborhood had already developed the instinct to keep their heads down when she was in the room. Not because she was physically intimidating, because she held the fine schedule, and everyone knew it. Within 18 months of taking office, she had turned 96 homes into a compliance project. Grass height violations at $75 a notice. Paint color changes that required formal board review and a processing fee. A curfew for community vehicle noise that had never existed in the original bylaws. Pushed through in a board amendment with 4 votes to 1. Cars towed from guest spots for being parked 2 inches over the designated line. I watched a family on Birchwood Court repaint their shutters twice in one summer because Karen changed the approved color list between the first inspection and the second. Nobody went to the mat over it. When the person running the meeting also controls the violation calendar, dissent has a price tag most people don't want to pay. 2 years ago, Karen started digging through old files in the HOA office cardboard boxes, physical folders, the kind of administrative archaeology that happens when someone has been in power long enough to start looking for more of it. What she found, in a box that probably hadn't been opened since the late 90s, was a developer's original site plan from 1987. Hand-drawn, rough lines. The kind of document a developer sketches out before a subdivision is fully completed, more intent than instruction, more suggestion than deed. On that sketch, the corner parcel at the end of the block was labeled in faded ink, Rec Area A. Here's what that sketch was not. It was not recorded at the county. No deed transfer had ever been filed on the basis of it. No title instrument existed to move that parcel from private ownership to common HOA land. It was a developer's rough idea from 35 years ago, preserved by accident in a cardboard box. Karen found it and treated it like scripture. At the HOA meeting 14 months before the morning I arrived with an excavator, she presented the cabin project on a projector screen. New community gathering space. Permanent structure. HOA community funds. Already budgeted. The 1987 sketch blown up large on the wall behind her. When 2 homeowners asked about ownership, she didn't pause for even half a beat. This land has always been HOA common property, she said. It was designated that way at founding. We are simply finally using it. The vote passed. Most people in that room had already learned it was easier to nod than to calculate the cost of asking a follow-up question. What happened next was less malice than inertia. Karen's contractor filed for a building permit listing the site as HOA, Lot 7, Community Rec Area. A junior county clerk processed it against the HOA's existing organizational record and issued the permit without cross-referencing the parcel's recorded ownership deed. The kind of gap that exists in every county permitting office in the country and almost never causes a problem right up until the moment someone uses it to break ground on land they've never actually owned. The permit came through. Construction was scheduled. Nobody called me. I found out the way you find out about most things in a neighborhood like this. A neighbor mentioned it while we were both getting our mail one morning. She had that particular careful expression people wore when they'd already calculated what it might cost them to say the wrong thing near the wrong person. Karen's building something on the rec area, she said, nodding toward my corner parcel. What rec area? She had no answer for that. Neither did the county assessor's office, as it turned out, when I called them an hour later. They had a deed for that parcel. They had 11 years of property tax payments on it. They had exactly one name attached to it. Mine. I asked them to pull a certified copy and hold it for pickup. Something told me I was going to need it on paper. Scene 3. She filed a fine for being right. The foundation stakes went in on a Tuesday. I was walking the parcel that morning, something I did a few times a week. Habit more than anything, when I noticed the contractor's crew. 4 men, surveying equipment, orange flags pushed into the ground at intervals. I walked to the nearest stake and looked at where it sat relative to my property line markers. 6 feet inside my boundary. I took out my phone and photographed each stake individually, timestamp running. Then I called the contractor's main number. He was cordial enough. He was working under HOA authorization, he said, on a community project. HOA had permits. He had a signed contract. He was just doing the job. I thanked him, hung up, and called Karen. She met me at the parcel 20 minutes later with the 1,987 sketch in her hand. I showed her my survey markers. I walked her along the property line, stake by stake, explained that the foundation grid her crew was laying sat entirely on land, with my name on the county record. I used plain language. I kept my voice level. I gave her every reasonable opportunity to say the words, "Let me look into this." She held up the sketch. "This entire area has been designated Rec Area A since this subdivision was founded," she said. "It has been HOA community land since 1987. She paused, and her voice took on a tone that I can only describe as magnanimous. The voice of someone gently correcting a person who can't quite help being confused. "Your purchase may have been a clerical error that was unfortunately never corrected. An 11-year-old county deed, annual property tax payments, a licensed title search completed at closing. All of that, apparently, was a clerical error." I told her again clearly, "Stop construction until ownership is verified with the county." She looked at me for a moment, the way you look at someone who has said something you consider beneath a direct response. Then she went back to her car. 48 hours later, an envelope appeared in my mailbox. Formal HOA violation notice. Harassment and obstruction of an authorized HOA improvement project. $500. Due within 30 days. Construction, the notice made clear, would continue. $500 for asking a woman to check whether she owned the land she was building on. I set the notice on my kitchen table and looked at it for a while. Not because I was deciding whether to pay it. I wasn't paying it. I was thinking about the gap between what Karen believed and what was actually recorded at the county courthouse 8 miles from where I was sitting, and how long it was going to take for those two things to meet. I drove to the county clerk's office the next morning. The clerk pulled my parcel record in under 3 minutes. Deed in my name. Purchase date, 11 years prior. Continuous tax payments, uninterrupted. Then I asked the other question, the one that I already knew the answer to, but needed confirmed on paper. Had any deed transfer to a homeowners association ever been recorded for this parcel? She checked. She looked again. She shook her head. No transfer. No HOA ownership instrument. No legal filing of any kind connecting that parcel to the homeowners association. The 1,987 sketch, whatever it said, had never been recorded as a legal document. It had never moved title. It had never done anything except sit in a cardboard box and wait for someone credulous enough to treat it like it had. I asked for a certified copy of my deed. She printed it, stamped it, handed it across the counter. I put it in my jacket pocket and drove home. That afternoon, I drafted a formal written notice to the HOA board. 1 page. Precise language. The construction currently underway was occurring on my legally recorded property. I was requesting immediate cessation of all activity on the parcel until ownership had been properly verified through county records. I was not making a request informally. I was making it in writing, with legal intent. I sent it certified mail to each of the 5 board members by name. Over the following week, all 5 return receipts came back signed. I laid them out on the kitchen table next to the $500 violation notice and looked at the arrangement for a moment. 5 signatures. 5 people who had now formally received written notice that the construction might be on private land. The return receipts had the date printed on them. Not one of them responded. Not a letter, not a phone call, not an email, nothing. Construction continued. At the next HOA meeting, Karen stood at the front of the room and referenced, with careful vagueness, an ongoing attempt by one homeowner to obstruct a community improvement project. She didn't use my name. She didn't need to. Everyone in the room knew whose corner lot sat at the end of the block. Afterward, in the parking lot, 3 families approached me. Not together separately, like they'd each decided independently, each one glancing back toward the building before they spoke. One woman, quietly, "We've all gotten fines we couldn't fight. Once she puts your name on the calendar, it doesn't come off." A man from Birchwood Court. "We stopped saying anything about 2 years ago. It's just easier." The third, a couple who'd been in the neighborhood longer than anyone. They just wanted me to know they were watching. They didn't say anything else. They didn't have to. I wrote down all 3 of their names when I got home. I had the deed. I had the certified letter receipts, 5 of them, signed, dated, unanswered. I had the county clerk's confirmation that no HOA ownership had ever been legally recorded on that parcel. But I needed one more piece. Something that would show, on paper, exactly how much of that cabin sat on my land and exactly when they'd built it there, relative to the date on those certified letters. I called a surveyor. Scene 4. The surveyor's report changed everything. The surveyor finished his work on a Thursday morning. I was there when he walked the boundary line for the final time, double-checking his measurements against the county plat. He was methodical, unhurried, the kind of professional who doesn't offer opinions until the numbers are complete and the report is written. He packed his equipment, shook my hand, and told me I'd have the signed report within 48 hours. It arrived in 2. I read it at my kitchen table with coffee going cold next to me. The language was technical in the way that land surveys are bearing coordinates, boundary markers, parcel references, but the conclusion was not technical at all. The cabin's footprint, the report stated, including footings, framing, floor structure, roofline, and all exterior walls, sat 100% within the boundaries of my recorded parcel. Not partly, not in a gray zone that a reasonable person might argue over. The entire structure. Every square foot of it. On my land. I read it a second time. Then I called Karen's office number. She didn't answer. I left no message. That afternoon I drafted the second certified letter. Where the first had been a request to stop construction, this one was different in tone. I attached the full survey report. I stated, in plain terms, that the continued presence of the HOA structure on my recorded parcel constituted illegal trespass under applicable property law, and that I was formally reserving my right to remedy the encroachment through any lawful means available to me. I sent it certified mail to each of the 5 board members by name, same as before. All 5 return receipts came back signed within the week. No response. No phone call. No acknowledgement that a licensed survey had just confirmed, in a stamped and county-filed document, that their cabin was sitting entirely on land they had never owned. The silence was its own kind of answer. Karen's response to the survey, when it came, was not a phone call or a letter or a meeting request. She posted a notice at the entrance to my parcel. Community Safety Zone. No unauthorized foot traffic within 15 feet of the HOA community cabin. I stood in front of that sign for a long moment. She had taken my land and built a structure on it. When I objected in writing, she fined me. When I hired a surveyor who confirmed the encroachment in a legal document, she responded by restricting my access to my own property. The sign didn't say HOA members only. It said unauthorized. On land the county had recorded in my name for 11 years. I photographed the sign. Date and time stamped. Then I walked my parcel anyway, slowly, all the way around the cabin perimeter. No one stopped me. But the sign stayed up. The paper trail was acquiring a new chapter. That same week, 3 separate families reached out to me. Not at a meeting, not publicly, privately, through the kind of careful, quiet channels that develop in a neighborhood where the wrong word in the wrong place carries a financial consequence. They weren't coming to me about my situation specifically. They were coming because they'd been watching, and they decided, for their own reasons, that it was finally worth the risk of saying something out loud. The first was a family 3 blocks over. The previous December, they'd put up Christmas lights on November 28, 3 days before the HOA's officially approved decoration start date of December 1st. Karen had sent a violation notice the same week, $1,200. They paid it because they'd heard what happened to people who didn't. The second was an elderly couple who'd been in the neighborhood longer than anyone else on the block. Over 3 years, They had accumulated $4,200 in fines, grass height citations, a mailbox replacement that didn't meet the new approved color specifications, a fine for a cracked section of their driveway that Karen had deemed a community aesthetic violation. They had paid every single one. They had never missed a payment, and they had never filed a complaint, because they believed, genuinely, that challenging Karen would result in a lien on a home they'd owned for 22 years. The third family had hired a contractor to build a pergola in their backyard. Karen had stopped the contractor mid-project, materials already delivered, half the posts set, and told him that the HOA required a new architectural approval submission because the original application had listed light wood finish, and the materials on site appeared to be a slightly darker stain. The family had paid the resubmission fee, waited 11 weeks for a new approval meeting, and rebuilt from the point where the contractor had been stopped. All three families gave me written statements, signed, dated, specific. I added them to the folder. 2 days later, I filed a records request. Most states give HOA members the legal right to access board meeting minutes. It's one of the few actual protections written into HOA governance law. I submitted a formal request under the state's HOA transparency statute for copies of all board meeting minutes for the prior 2 years. The HOA had a legal window to produce them. They came in just before the deadline, 41 pages, formatted in the particular style of someone who'd never expected anyone to actually read them carefully. I read them carefully. Most of it was standard administrative record fine schedules, budget approvals, vendor contracts. Then, in the minutes from a meeting held 4 months before construction had begun on my parcel, I found a single paragraph. Boundary question raised by adjacent homeowner regarding proposed Rec Area A improvement site, board discussed. Voted 4-1 to proceed with improvement project regardless of homeowner's claim, pending HOA council review. I read that paragraph 3 times. They had known. Before the first stake went into the ground, before the first board of lumber arrived, before the contractor's crew showed up on my property, someone had raised the boundary question. It was in their own minutes. They had voted to build anyway. And the HOA council review that was supposed to follow that vote? I went through the remaining minutes page by page. It never appeared again. They had noted it, voted to proceed regardless, and then simply stopped asking. I called a property rights attorney the next morning. We met in his office that afternoon. I laid out everything on his conference table, the county deed, the survey report, the 2 certified letters with all 10 signed return receipts, the construction photos time-stamped after the first letter's delivery date, the meeting minutes with that paragraph circled, and the 3 written neighbor statements. He went through it without saying much, about 20 minutes. Then he put the last document down and looked across the table at me. "This isn't complicated," he said. "The moment a judge sees this deed and this survey, the HOA has nothing. They built on private land. They were warned twice in writing, and their own minutes show they knew about the dispute before they broke ground." He picked up the meeting minutes and held them for a moment. "Your only real question is how long you want to wait before acting." I told him I'd already started thinking about that. Scene 5. The lien on my house. The cabin came down on a Friday morning. By the following Monday, I was back at work, back to my regular routine, the parcel sitting quiet and clear at the end of the block, with nothing on it but survey stakes and flattened ground. I had kept my attorney's number in my phone since our meeting. I expected to hear from the HOA. I expected it to be unpleasant. I did not fully anticipate 41 pages. The civil complaint arrived 10 days after the demolition, delivered by a process server to my front door at 7:15 on a Wednesday morning. I signed for it, set it on the kitchen table, and read through it with coffee. All 41 pages. Count 1, willful destruction of HOA property. Count 2, intentional infliction of community harm. Damages sought, $47,000, stated as the cabin's full construction and materials cost, plus attorney fees, plus additional damages for ongoing community harm to be calculated at trial. The first page described me as a reckless actor who unilaterally destroyed a structure belonging to 96 families. 96 families. That number appeared 6 times in the first 10 pages. I read the rest carefully. Exhibits attached. Photos of the cabin before demolition. Photos of the cleared lot after. A copy of the HOA's construction permit. The county deed for my parcel, the one with my name on it, did not appear anywhere in the document. Neither did the survey report. Neither did the 2 certified letters, both signed for. Neither answered. 41 pages, and not one of them acknowledged that the cabin had been built on private land. 3 days later, A second letter arrived. A formal lien had been placed on my home by the HOA's attorney's office. $47,000 plus accumulating fees, recorded against my property title. Until the civil suit was resolved, my home title was clouded. I could not sell, refinance, or transfer the property. A separate notice accompanied the lien filing. If I did not agree within 60 days to fund the cabin's reconstruction, foreclosure proceedings would begin. I sat with that one for a while. Foreclosure. On a home I'd owned outright for a decade, paid in full, for demolishing a structure that a licensed survey had confirmed was built without my permission on land that had carried my name at the county courthouse for 11 years. I called my attorney. His response after a pause: "They've lied to their own lawyer." Karen moved fast on the social front too. Within a week of the lien filing, a petition was circulating through the neighborhood. Printed copies in mailboxes. A digital version linked from the HOA's community board. The language was careful. No direct accusations, just a call for community solidarity in restoring what was lost and support for the HOA's legal action against the homeowner responsible for the destruction of our shared space. 71 signatures came back. I knew most of those names. I understood, without bitterness, that most of them had signed because they believed Karen, or because they'd seen what happened to people who didn't. 25 homeowners didn't sign. The 3 who'd given me written statements didn't sign. I noted that without making anything more of it than it was. 71 people had just put their names on a document, calling me a vandal. The county deed in my filing cabinet had one name on it: mine. Only one of those documents was going to matter in a courtroom. My attorney had the civil complaint on his desk. By the end of the day, I received it. He called me that evening. "Let me make sure I understand this correctly," he said, and I could hear him turning pages. "They're filing a $47,000 damages claim for a cabin they built on your land without your permission, which you demolished with a valid county permit, after sending them 2 certified warnings they signed for and ignored." Another page turning. "And their first exhibit is the construction permit, which they obtained by listing the site under the HOA's parcel designation without verifying the ownership deed." "That's correct. And their own board minutes, which you have a copy of, show they voted to proceed after the boundary question was raised." "Also correct." A short pause. "This case has one outcome," he said. "The only question is how much it costs them to find that out." We filed our legal response 8 days later. Motion to dismiss the civil complaint. Counterclaim for illegal placement of a lien on private property. Counterclaim for trespass construction on recorded private land without the owner's consent. Counterclaim for property damage, the cost of clearing the foundation rubble and restoring the parcel. Everything attached in full. The county deed, the licensed survey report, both certified warning letters with all 10 signed return receipts, the construction photos time-stamped after the first letter's delivery date, and the HOA board meeting minutes, with the paragraph about the boundary vote clearly marked. The complete package, on record, in court filings. 2 days before the hearing date, my attorney called again. Karen's legal team had filed a motion to have my demolition permit invalidated. Their argument: I had misrepresented ownership to county permitting officials when applying for the permit. I let that sit for a moment. They were arguing, in a court filing, that the county clerk's office had made an error when it issued a demolition permit tied to the recorded owner of record's parcel number. They were arguing that the county's own property records were wrong. My attorney's voice had something in it I hadn't heard before, not quite amusement, but close. They just turned a property dispute into an attack on county record keeping, he said. I want you to understand something. A judge is going to read that motion, and then the judge is going to look at your deed. And it is going to be a very short morning. 3 weeks earlier, Karen had stood on my parcel with her palm flat on an HOA placard and told me I was wrong about who owned the land beneath her hand. Now her attorney had filed a motion arguing the county courthouse itself had made a clerical error. She had bet everything, the lawsuit, the lien, the petition, 41 pages of legal argument, on a 1,987 hand-drawn sketch that had never been recorded as a legal instrument anywhere in the history of this county. In 3 weeks, we had a court date. Scene 6, the meeting where Karen believed she'd already won. The mandatory attendance notice arrived in every mailbox on a Thursday. Community restoration and legal strategy briefing all homeowners are expected to attend. The meeting was scheduled for the following Tuesday evening in the neighborhood's community room, a space Karen had reserved, apparently, the same day the civil complaint was filed. She had planned this before the ink was dry on the lawsuit. I RSVP'd by showing up. She had transformed the room. Printed binders at every seat, 40 pages, tabbed, the HOA logo embossed on the cover, a projector screen at the front, a podium, 2 board members flanking her like assistants at a press conference. When I walked in and took a seat in the back row, Karen was arranging her notes at the podium with the focused calm of someone who had rehearsed this several times and was satisfied with how it was going to go. I set my phone on the table in front of me and pressed record. In most states, recording a meeting you're lawfully attending is entirely legal. I'd checked. The room filled around me. 90-something homeowners in folding chairs, the particular low murmur of a crowd that isn't sure what it's about to watch. I recognized faces. Some people nodded at me. Some looked away. I kept my expression neutral and my back straight and waited. Karen tapped the podium twice, and the room went quiet. She opened with the demolition photos. Full screen, projected large my parcel, the excavator, the cabin's framing coming apart. She let them sit on the screen for a moment before she spoke. This, she said, is what one homeowner decided to do to a structure that belonged to every family in this room. She was composed, authoritative, her voice carrying the particular register of someone who has been the most powerful person in every room they've entered for the past 6 years. She walked the audience through the HOA's version of events, the 1,987 founding plat identifying Rec Area A, the board vote, the community funds invested, the construction completed. She showed the 1,987 sketch on the projector enlarged, centered, presented as a primary document. She did not show a deed. She did not mention the county's ownership record. She did not mention the license survey. She did not mention the 2 certified warning letters. She moved through the entire presentation 22 minutes. I clocked it without acknowledging that any of those things existed. I wrote down the timestamp and kept my face still. When she opened the floor for comments, a board member to her left immediately moved to recognize only non-involved homeowners. The phrasing was practiced. They'd discussed this part. I raised my hand anyway. Karen looked at me across the room. Something moved behind her eyes, not surprise, more like the particular expression of someone who had anticipated an obstacle and had already decided how to handle it. This is an HOA meeting, she said, not a legal proceeding. You've already made your position very clear with a demolition crew. You don't get to perform here too. 2 homeowners in the row ahead of me looked at the floor. I put my hand down. I picked up my pen. I let her keep the room. She didn't get to keep it entirely. 3 homeowners spoke up during the comment portion, not together, not coordinated as far as I knew. Just 3 people who had apparently decided that this particular meeting was the one where they'd say something. The first mentioned the survey report. Karen talked over her before she finished the sentence. We're not here to relitigate the legal question. That's what the courts are for, and moved to the next raised hand. The second, a man I recognized from Birchwood Court, stood up and asked why the HOA's own attorney hadn't addressed the certified letters in the complaint documents he'd read. Karen pointed to a board member on her right. Conduct violation noted for the record. The man sat down slowly, his jaw tight. The third managed one complete sentence. The survey says the cabin was entirely on his land before Karen's voice came down over hers like a door closing. We are not relitigating a closed board decision in this meeting. If anyone has specific legal concerns, those can be submitted in writing to the HOA's counsel. The room was uncomfortable in the way rooms get when people feel something is wrong and have calculated that saying so will cost them more than staying quiet. Not everyone was with her, but most of them were still in their seats, saying nothing. And for Karen's purposes in that room, silence and agreement were functionally the same thing. She closed with a statement she'd clearly prepared. We are going to prevail in court, she said, with a certainty I had to admire on a technical level. The community cabin will be rebuilt. The cost of that reconstruction will be recovered from the homeowner who destroyed it. We have documented community investment. We have a founding plat that clearly designates this area. She paused and looked across the room. We have the whole neighborhood behind us. One old deed is not going to change what has always been true. I wrote that last sentence down word for word in my notes. One old deed is not going to change what has always been true. She closed the binder in front of her. The meeting was adjourned. I was almost to my car when 2 more families caught up with me in the parking lot separately, within 30 seconds of each other. They hadn't signed the petition. They'd been watching. One man pressed a folded piece of paper into my hand, without much preamble. 2 years ago, Karen had made a similar boundary claim about his backyard fence. told him the rear property line ran 3 feet inside where it was actually recorded, citing, he later found out, the same 1,987 sketch. He'd paid a contractor to move the fence rather than fight it. He'd written down the dates, the amounts, the conversations. He'd kept it because he wasn't sure why, only that it felt like the kind of thing that might matter someday. I thanked him and folded the paper into my jacket pocket. I wasn't going to need it in court. What I already had was sufficient, and my attorney had told me so clearly. But I took it because the man had held on to it for 2 years, waiting for a moment when someone might actually use it. And the least I could do was carry it the rest of the way. I had my hand on my car door when I heard Karen's voice, drifting through the open window of the community room behind me. She was on the phone, already in the post-meeting debrief. The particular energized tone of someone walking through a room they believe they've just won. The judge won't care about some old deed, she was saying. We have community investment. We have documented use. We have the whole neighborhood on record. 6 years as HOA president. 6 years of fines and votes and meetings, and 144 homeowners learning which arguments were worth having, and which ones came with a price tag. In all of that time, she had never once been wrong about something in a room where the person deciding the outcome had the authority to tell her so. That was 3 days away. Scene 7. The judge read the deed out loud. The courtroom was smaller than I'd expected. Wood paneling, fluorescent lighting, 2 tables facing the bench with a narrow aisle between them. Karen and her attorney were already seated when I arrived with my own counsel. She had a binder in front of her, the same tabbed format as the community meeting. She didn't look at me when I sat down. I set my copy of the deed on the table in front of me, face down. The judge came in at 9:14. He had the particular economy of movement of someone who spends their days sorting through other people's certainties, and has developed a reliable instinct for which ones will survive contact with the record. He sat, opened the folder in front of him, and nodded at the HOA's attorney to proceed. The HOA's attorney was polished and prepared. He opened with the community investment argument, the HOA's founding history, the 1,987 designation of Rec Area A, the board vote, the community funds expended. He described my demolition as a unilateral act of destruction against a structure belonging to 96 families. He said the word community 11 times in 4 minutes. I counted. Then he placed the 1,987 sketch before the judge as Exhibit A. This is the HOA's founding land designation document, he said. It clearly identifies the site in question as community recreational property since the subdivision's inception. The judge picked up the sketch. He looked at it for a moment, not long, maybe 15 seconds, and set it back down. Counsel, he said, where is the recorded deed for this parcel? Who does the county have as title holder of record? The HOA's attorney didn't hesitate. Your Honor, the founding document establishes the HOA's historical claim to this area and the community's reliance on that designation. The judge looked up from the sketch. I asked about the county's deed record. The room went very quiet. My attorney stood. Your Honor, the county has never recorded any HOA ownership of this parcel. He placed the county deed on the bench. One document, my name at the top, the parcel number, the same number printed on the demolition permit I'd handed to the officer on the morning the cabin came down, running along the header. 11 years of recorded ownership. He followed it immediately with the license survey report, the plat overlaid with the cabin's footprint, every square foot of the structure sitting inside my boundary lines. This gentleman has owned this land since before the HOA built their cabin, my attorney said. The county's records have always said so. The judge pulled both documents toward him. He looked at the deed first, then the survey. Then he picked up the 1,987 sketch again, held it beside the deed, and examined them together. He set the sketch down on the far side of his desk. This sketch, he said, was never recorded as a legal instrument at this county. It wasn't a question. Karen's attorney moved fast. Your Honor, the defendant never formally notified the HOA of any ownership dispute. My attorney opened the first folder. 2 certified letters, both dated, both with the signed return receipts, attached all 5 board members, all 5 signatures, all 5 dates. Both letters were received and signed for, he said. Neither was answered. The HOA attorney shifted in his chair. Construction was substantially complete before any notice. Second folder. Time-stamped photographs, the cabin's framing continuing on dates that fell after the first letter's confirmed delivery. Construction continued after written notice, my attorney said. The timestamps are on the photographs. I watched Karen's attorney look at the photos. He looked at them for slightly longer than was comfortable. The judge hadn't said anything. He didn't need to. My attorney opened the third folder. Your Honor, I'd like to direct the court's attention to the HOA's own board meeting minutes from a session held 4 months before construction began. He placed the minutes on the bench and pointed to the paragraph I'd read 3 times at my kitchen table. The judge read it aloud. Boundary question raised by adjacent homeowner regarding proposed Rec Area A improvement site. Board discussed. Voted 4-1 to proceed with improvement project regardless of homeowner's claim, pending HOA council review. He looked up from the page. His eyes moved to Karen. She was very still. Was this council review ever completed? The judge asked. Her attorney answered carefully. Your Honor, the board acted in good faith based on the founding. I asked whether the council review noted in the minutes was ever completed. A pause that lasted too long. It was not completed prior to construction commencing. Your Honor. The judge set the minutes down and looked at them for a moment. Then he looked at the HOA's attorney's motion to invalidate my demolition. Permit the one arguing the county clerk had made an error when issuing a permit to the owner of record. Counsel, I've reviewed the motion to invalidate the demolition permit. The permit was issued by the county to the recorded owner of this parcel, tied to his parcel number. He picked up my deed and held it briefly. Motion is denied. Then he looked at Karen directly. I'm looking at a county recorded deed, a license survey, 11 years of property tax payments, 2 formal written warnings that were signed for and ignored, and board meeting minutes showing this board knew about the ownership dispute before construction began and chose to proceed anyway. He set the deed down with the particular finality of someone placing the last piece of something. The demolition was lawful. The lien is void. Karen came out of her seat. Your Honor, that plat is the original document. Our attorney approved this project. The entire community voted. Your founding document is an unrecorded developer's sketch. The judge's voice didn't change register at all. Same volume, same pace. It carries no legal weight against a registered deed. Please be seated. We have invested community funds. We have. That is a matter between you and the members of your association. He looked at her steadily. It is not a matter between you and this man's property deed. Please, be seated. She sat. Her hands were flat on the table in front of her, pressed down hard, and she was staring at the surface of it. Then, I will appeal every single part of this ruling. The judge looked at her attorney, not at her. Counsel, you should be aware that if an appeals court finds this position frivolous, your client will be responsible for the defendant's full attorney fees at that stage as well. I would encourage a candid conversation before any appeal is filed. Her attorney nodded once. He placed his hand briefly on Karen's arm. She didn't acknowledge it. She stared forward for the rest of the hearing without speaking. The ruling took 4 minutes to deliver. The HOA's civil complaint, dismissed with prejudice. The lien on my home, voided, to be removed from county title record within 30 days by court order. My counterclaim for the illegal lien placement, upheld. Damages awarded. My counterclaim for trespass, upheld. Damages awarded. Total awarded to me, $14,200, covering legal fees, survey costs, and the cost of clearing the foundation rubble from my parcel. The HOA board was formally notified that any future property improvement project undertaken on land without verified county title documentation would constitute grounds for an immediate injunction. The judge closed his folder and left the bench. Karen and her attorney walked past me in the hallway. She didn't look at me. She said nothing. Her attorney was already on his phone before they reached the door, and I caught a fragment of the conversation measured, careful language, the tone of someone who has to explain a bad outcome to a client who wasn't expecting it. Outside the courthouse, 3 of the neighbors who hadn't signed the petition were waiting on the steps in the thin morning light. They hadn't been inside. They'd simply come. No one said anything. One of them nodded at me. I nodded back. That was enough. Scene 8. The last morning I had to think about it. The lien came off my title on a Wednesday. 31 days after the ruling, 1 day past the court's 30-day deadline, which my attorney noted in a brief letter to the HOA's counsel, who responded within the hour. By noon, the county had processed the removal and updated the record. I pulled up my property file online that evening, the same county portal I'd used 11 years ago when the purchase closed, and looked at my parcel record for a while. Clean title. My name. No encumbrances. I closed the laptop and went to bed at a reasonable hour for the first time in about 3 months. The $14,200 arrived as a check from the HOA's legal account, issued under protest according to the cover letter, which I read once and set aside. It covered my attorney's fees in full, the licensed surveyor's invoice, and the cost of clearing the foundation rubble and hauling it off my parcel after the demolition. The math worked out to almost exactly what it had cost me to be right. The HOA's own legal fees were not disclosed to me directly, but the community fund balance was, eventually, because two homeowners filed a formal accounting request at the next board meeting, which was the right of every member under the same state transparency statute I'd used to pull the meeting minutes. The accounting came back 3 weeks later. The lawsuit had cost the HOA's community fund $63,000 in legal fees and awarded damages combined. It was nearly the entire operating reserve. Karen had never put it to a full homeowner vote before filing suit. When that fact became clear in the accounting documents, a separate board inquiry was opened into whether she'd had the authority to spend community funds on litigation without member approval. The short answer, as the new board's attorney explained at a subsequent meeting, was that she had not. Karen's resignation arrived by email 11 days after the ruling. One paragraph: personal health considerations. Effective immediately. She did not reference the lawsuit, the lien, the courtroom, or the parcel at the end of the block. 3 board members sent their own resignation emails within the same week brief. Similarly vague, the kind of letters written by people who have realized they're standing on the wrong side of a documented record and would prefer to stop standing there. Emergency HOA elections were announced for the following month. 2 of the neighbors who had given me written statements put their names forward as candidates. Both of them won, which did not surprise me. When the previous leadership structure has just spent $63,000 of community money on a lawsuit it lost in a single morning, the bar for the alternatives is not particularly high. The first meeting under the new board was held on a Tuesday evening. I didn't attend. I didn't need to, and I didn't think my presence would make it easier for the room to move forward. I heard about it afterward from one of the new board members, who called me the following morning. The 1,987 developers sketch had been formally removed from HOA records and marked as having no legal standing as a property ownership instrument. A notation was added to the file: unrecorded developer's site plan, no title authority, not to be used as basis for any HOA land claim. All fines issued during Karen's tenure had been submitted for individual homeowner review. The process would take several months to complete. For the elderly couple on the block, the ones who had paid $4,200 in fines over 3 years, for grass height and a mailbox color and a cracked section of driveway, the new board had already voted on a resolution before the meeting ended. A formal written apology and a full refund, drawn from what remained of the community fund. I thought about that couple for a while after I hung up the phone. They had paid every fine without complaint for 3 years because they were afraid of losing a house they'd owned for 22 years. That fear had been entirely manufactured, entirely deliberate, and entirely without legal foundation. The refund didn't give them 3 years back, but it was something. 2 weeks after the ruling, on a quiet weekday morning, I walked the parcel. The foundation rubble was gone. I'd hired someone to haul it the day after the demolition, before I'd even known about the lawsuit. The ground had settled. The survey stakes stood clean along the property line, the same orange-tipped markers that had been there when Karen walked me along them and told me my ownership was a clerical error. The lot was flat and quiet, morning light coming in low from the east, a few weeds already starting to come back along the edges. I stood in the middle of it for a few minutes. Not triumph. That's not quite what it was. More like the particular quality of silence that arrives when something you've been carrying stops needing to be carried, a weight you'd gotten so used to that you only noticed it was gone once your shoulders came down. I walked back to my truck and drove home. That afternoon I opened the filing cabinet in my home office. I took out the deed, the same document that had sat in that envelope on my truck dashboard, while Karen stood on my parcel and told 2 police officers and 6 of my neighbors that the county's records were wrong, and I had no right to be there. I looked at it for a moment. My name, the parcel number. 11 years, same as always. I slid it into the hanging folder, closed the cabinet drawer, and turned off the light. She called it community property. The county called it mine. So did the judge. That was the last morning I ever had to think about it.